Welcome everyone to the Global State of Citizenship Seminar Series, launch event of the updated GLOBALCIT Citizenship Law Dataset. During the next hour, we will learn about the latest global outlook on citizenship based on the exciting release of the second version of the GLOBALCIT Citizenship Law Database, which covers 191 countries and includes new data for 2022, among many other exciting changes that we will be hearing about shortly. My name is Lillian Frost, and I am an assistant professor of political science at Virginia Tech, and I specialize in citizenship, migration, and gender issues, particularly in the Arab world, and specifically in Jordan. So having written the country report on Jordan and spent the 2020-2021 academic year at the Schumann Center, I am particularly excited to hear from our esteemed speakers and commentators today. So before introducing the speakers, I would like to make just two quick administrative notes about the session. So first, it will be recorded and will be available at globalcit.eu shortly after we conclude today, or at some point after we conclude today. So if you need to leave early or have a colleague who couldn't make it, please make a note that no worries, there's a recording that will be available. And secondly, please be sure to make use of the Q&A, the question and answer chat function at the bottom of your screen at any point during the webinar. Once our speakers and commentators conclude their presentations, we will turn to a broader Q&A to include the full audience. So please make use of that function at any point during the webinar. All right, without further ado, let me introduce our three speakers, and then afterward, I will introduce our three commentators. First, we have Martin Vink, who really probably doesn't need too much of an introduction, but is chair in citizenship studies and director of the Global Citizenship Research Area within the Global Governance Program at the Robert Schumann Center for Advanced Studies at the European University Institute. He is also co-director of the Global Citizenship Observatory, which we've been referring to here as GLOBALCIT. Next, we have Bronwyn Manby, who is a Jean Monnet Fellow at the Robert Schumann Center for Advanced Studies of the European University Institute, where she works with the Global Citizenship Research Program. She has also written very extensively on comparative nationality law, statelessness, and legal identity, especially in Africa. And lastly, among our speakers is Luc van der Bagen, who is a postdoctoral researcher in global mobility law at the University of Copenhagen and a GLOBALCIT Senior Research Associate at the European University Institute. Luc coordinates GLOBALCIT's comparative work on modes of acquisition and loss of citizenship, and he also works on updating the GLOBALCIT Citizenship Law Dataset. So much thanks, I'm sure, is due to Luc for getting all of those updates done. All right, so each of the speakers will have 7 minutes. I will hold up a finger when you have 1 minute left, and I will interject if you abuse your time just a little bit too much. And so let's go ahead and get started with Martin Vink.
Thank you, Lily, and good afternoon or good morning, everyone. It's really a great pleasure to speak here today on behalf of the team that has worked on the GLOBALCIT Citizenship Law Dataset. We published the first version in December 21, and we're really excited to publish now version 2, which will be the first of annual updates. So we are expecting a next update in the version 3 to be published in 23. So the citizenship law dataset covers citizenship law around the world. We can really provide you with the global state of citizenship. It covers 191 countries around the world. The situation in 2020, 21, and 22. And in addition, we have also longitudinal data that goes back to 1960 for a subset of indicators, which I will explain to you in a moment, which covers 10 other countries. So up to 201 countries covered in the data set. Now, the Citizenship Law Dataset is one of the many things that we do at GLOBALCIT. You can find all the information at globalcit.eu. Many of you will be familiar with this already. But in addition to the data collection, we have also ongoing debates, for example, on international law and oppressive nationality attribution, or book review symposiums, literature references. So there's a lot of information that you can find, and country profile pages as well. Now, the Citizenship Law Dataset aims to cover comprehensively all the different ways in which you can acquire the citizenship of a country or lose it. Well, the good news is that there are actually many more ways to acquire citizenship than to lose it. The good news from the perspective of inclusiveness. But there are also worrying trends, and I will address some of the trends, and my colleagues Bronwyn Mendy and Luc van der Baren will jump into some of this in more detail. Now, the Citizenship Law Database can be explored both in an interactive manner on our website in the online databases, and you see this on the screen in front of you, as well as can be used in a coded form in the data sets that are posted in the repository, and I will show you some illustration of what you can do with that in a moment in order to get a sense of the global state of citizenship. So the online databases, we have one on acquisition of citizenship, and another one on the loss of citizenship. In our comparative approach, we break down the citizenship legislation of all of these countries into what we call comparable modes of acquisition or loss. Now, this is important because citizenship laws are highly idiosyncratic. They're actually not so, in many ways, the comparison is quite challenging, but we aim to achieve this comparability by breaking down the citizenship laws into standardized categories in which you can acquire it or lose it. So when we look at acquisition of citizenship, our first mode of acquisition, for example, refers to descent for people who are born in a country and one or both of their parents are a citizen. Of course, you can also acquire citizenship by being born in the country in some countries, even if your parents are not a citizen, or you can acquire it by residence-based acquisition, naturalization, or facilitated ways if your partner is a citizen. And once you go into these online databases, you will find detailed information on the nationality law to which the information refers. The article in the law, summary information on the main provision, a link to the nationality law in our nationality law database, and also a categorized form in which we categorize all these different provisions into a limited set of categories, and that allows us to compare across countries. And once we dive into the material a bit deeper, and there are many ways that you can play with the data, so I can only illustrate a couple of these ways. But the first thing that I think is very interesting is to look at, and it may be the biggest variation across all these 191 countries, in how many ways can you actually become a citizen of a country? And you will see this varies enormously. So in some countries, there are only a few ways in which you can become a citizen. And in Uruguay, for example, there are only 2 ways in which you can become a citizen by birth. There's a third way in which you can become a citizen through where you can become a legal citizen, but the status of that citizenship is unclear. So we don't treat this as a fully recognized citizenship in our data set. On the other extreme, there's even a country where there are 23 ways in which you can become a citizen, and this country is Greece. In general, you can see that in Europe, there are European countries, there are many more ways in which you can become a citizen, and outside of Europe, the ways to become a citizen are more restricted. Generally speaking, in democracies, there are more ways in which you can acquire citizenship, and in autocracies, there are fewer ways to acquire it. For loss of citizenship, this is the opposite. So in autocratic countries, typically you are at a greater risk to lose your citizenship. Luc van der Baren will talk more about citizenship deprivation, whereas in democracies, there are fewer ways in which you risk losing the citizenship. But again, in Uruguay, for example, there is no way in which you can lose your Uruguayan citizenship. Once you are a citizen, you will remain a citizen. Whereas in other countries, there are many more ways to lose your citizenship, either by voluntary renunciation or by deprivation based on acquiring a citizenship abroad or security concerns. Now, another way in which you can explore our data is looking at geographical variation. So, for example, when we look at the acquisition of citizenship at birth, there are some countries around the world that practice so-called jus soli provisions. So the right to citizenship by being born on the territory of a state, irrespective of the citizenship of the parents. The United States is maybe the best example. So this is colored in green on this map. And in most of the Americas, we see that there is territorial birthright citizenship. Now, what we see when we look at the rest of the world is that it's not the case that some countries have jus soli and others don't. So there are also hybrid categories. And we see this in Europe, Africa, Australia, where you might acquire the citizenship of the country by being born on the territory of that state, if your parents have a certain resident status, or if one of your parents is born on the territory of that country. This is sometimes called a double jus soli. Now, this indicator is a new indicator in the data set. It's called GLOBALCIT /combi. And this is where we combine two previous indicators that are in the data set. So going to the penultimate slide, we also add longitudinal data to the data set on a selection of indicators that have to do with dual citizenship. 3 indicators in particular. Can you voluntarily renounce your citizenship? First of all. Secondly, what happens when you lose the citizenship, what happens when you acquire citizenship abroad? And if you want to become a citizen of a country, do you have to renounce it? And what we see is that it's actually very remarkable, since citizenship law is so idiosyncratic. We would expect a lot of variation across countries, but at the same time, we see a very strong trend across all countries, namely towards the increasing acceptance of dual citizenship. So up to 49% of countries now fully accept dual citizenship, whereas only 21% of countries fully restricts it. And then there are some countries in between. Lily signaled that I should stop, so I will do this. Let me just highlight the team that is behind the coding. You see also Bronwyn and Jelena here in the session. I invite everyone to explore this, and thanks a lot for joining us online.
Thank you very much, Martin, and thank you for wrapping up quickly. So now let's turn to Bronwyn Manby.
Thank you. Can you just confirm that you can see my screen?
Yes. Yes.
Thank you very much. So I'm going to talk to a blog post that I wrote that is based on the data set that you can find on the GLOBALCIT website. I'm talking about discrimination, which my conclusion is perhaps somewhat obviously, but interesting in the details, that discrimination is increasingly rare in the law, but it remains pervasive behind the scenes. The first thing to note, looking at citizenship by descent, where discriminatory provisions are most common, is that most countries do not have discrimination in transmission of citizenship from a parent. Very large majority in relation to children born in the country, a slight majority in relation to children born outside of the country. Gender restrictions are steadily reducing. If we combine all the provisions together, we have about we have 22 countries that discriminate on the basis of descent, the sex of the parent, another 8 with discriminatory provisions based on wedlock. We also have 4 countries where there is discrimination based on group status, race, ethnicity, religion. This is perhaps a little misleading because it does this, the need to create exclusive categories doesn't include the preferential rights that exist. You need to delve more deeply into the data set to see the preferential rights and how they may also affect discrimination in citizenship transmission. Final point to note here is that restriction on citizenship transmission to children born abroad remains quite common and, in fact, explains most of the restrictions that exist in relation to children born abroad. Let us look then at citizenship based on birth in the country. Most countries do not have a general jus soli provision. It's restricted to foundlings or otherwise stateless children. However, jus soli provisions do remain quite common. The double jus soli provision or some form of restricted transmission. Gender restrictions are relevant in some of the countries with double jus soli provisions, and the same countries that discriminate on a group basis in relation to race, religion, etc., do the same in relation to jus soli provisions. Thirdly, looking at marriage, a generally applicable provision without gender equality is now by far the majority of cases. But at the same time, one must note that facilitated acquisition of nationality based on marriage has reduced. So as equalization has happened, acquisition of nationality based on marriage has become more difficult. And in that 65% with the generally applicable provision, you see a wide range from based on option, you just fill in the form and you get it, through to really quite onerous conditions. Final slide, which I will talk most about, is looking at how does the data set relate to what's happening in the real world. And one of the things to point out is just the challenges of doing coding, even looking at the law in its own right. And I can illustrate that by comparing GLOBALCIT coding with UNHCR coding in relation to sex discrimination. UNHCR produces an annual report. They have, as of this year, 24 countries that discriminate in transmission of nationality to children. GLOBALCIT has 22. One of those is, one discrepancy is easily explicable. The GLOBALCIT database cuts off at the end of 2021, and Liberia changed its law last year, reducing GLOBALCIT to 21, but there are 3 countries where UNHCR codes discrimination and GLOBALCIT codes as no discrimination. Both are valid choices, and it relates to the conflict of laws. There's a constitution that provides for equal transmission, but the nationality law discriminates. They're both valid choices, but they indicate how it's not as simple as saying that there is discrimination or there is not. There are always these challenges in the coding decisions. There are also challenges in creating mutually exclusive categories, which I could talk about in more detail as I was writing the blog, discovering how overlaps of some of the categories are challenging, and you really need to go into the data set to see how these different types of restriction interact with each other. There are also forms of discrimination that are not in the data set, and the one I highlighted is disability, which is there. You can go in and look it up in relation to restrictions based on welfare dependency and income. But the number of countries have naturalization restrictions based on good physical and mental health, which would surely discriminate against disabled people, and I think could perhaps be highlighted in a future edition. The most important point I want to make, however, is in relation to the group restrictions and the interaction of preferential provisions in allocation of or attribution of citizenship at birth and residence-based naturalization. If in practice it's really impossible to naturalize, the preferential right to nationality based on a group membership will be the dominant form of acquisition of nationality, because there are no naturalized citizens of a different group to transmit nationality to their children. And it's really in that intersectionality between birthright citizenship and naturalization that a huge amount of discrimination is disguised, even though you can say, theoretically, it's possible to become a citizen without being a member of that group. And so my final point is discrimination does not stop at legal provisions. The data set is an incredible resource, especially if you really get into the weeds of the details of all the different provisions. But there's really no substitute for finding out what's going on in the real world. And thank you very much. I should stop there.
Excellent. Thank you very much, Bronwyn, and well within time. So let's now turn to Luc van der Barren.
Okay, can you see my screen? Okay, perfect. All right, so I will briefly speak about the securitization of citizenship. So in recent years, we have seen worrying cases of citizenship deprivation on security grounds. An example is the United Kingdom, where more than 400 people have been stripped of their citizenship on security grounds since the mid-2000s. A very recent example is Nicaragua, which this year amended its citizenship law in order to allow deprivation of citizenship on the ground of treason from political prisoners. So what I will briefly discuss is how the GLOBALCIT dataset can help to map such provisions, and also how it can help to track developments in this regard over time. So first of all, the big picture. In the GLOBALCIT dataset, we distinguish 4 grounds for loss of citizenship that are in a way related to security. So the first one is service in a foreign army, and then other services to a foreign country, for example, taking up public office in another country. Then most importantly, disloyalty or treason, a mode for loss of citizenship that is present in 131 countries. And lastly, loss of citizenship due to other offenses, which is loss usually due to serious criminal offenses, but offenses that do not necessarily amount to disloyalty or a breach of the security of the state. So if we look at the different regions, we see certain stark differences between the regions. So overall, we see that provisions for security-based deprivation of citizenship are the most common in Africa and Asia. That does not mean that deprivation of citizenship on these grounds also takes place the most in these regions. It just means that the legal framework for citizenship stripping is most present in these particular regions. A region that stands out in this regard is Europe, where most security-related deprivation grounds are relatively uncommon, but where citizenship loss due to disloyalty or treason is present in more than half of the countries. So zooming in on disloyalty, we define loss based on disloyalty as loss due to behavior that is based on the concept of disloyalty or harm to the interest of the state or security of the state. So as I already mentioned, such provisions are present in 131 out of 191 countries. What is striking here is that in the abundant majority of these countries, 88, this provision is only applicable to certain groups of citizens, usually only to citizens of naturalization. And those provisions, so if the disloyalty provision is only applicable to naturalized citizens, this is mostly the case in African countries and Asian countries. So in Europe, if this provision is present, it is usually generally applicable, so applicable to all groups of citizens. So in addition to these categorizations, we also provide a specification for each of these provisions, which provides more specific conditions on which citizenship can be lost in this case. And what is striking in this regard is that the provisions are usually very broad in scope. So they use terms like national security or state interest without really limiting these terms or defining what these terms actually means. And what is also striking is that in many cases, prior conviction is needed for loss of citizenship on this ground, but that this is certainly not the case in all of these countries. Last year, GLOBALCIT, together with the Institute for Statelessness and Inclusion, presented a report on this particular topic, where we track developments regarding citizenship stripping due to disloyalty between the year 2000 and the year 2020. And what we found out was that these provisions are on the increase, particularly in Europe, and also that their scope has extended significantly, again, particularly in the European region. And this leads to certain serious concerns. First of all, arbitrary deprivation of citizenship, particularly in cases where there are limited possibilities for appeal, and also particularly in cases where no prior conviction is needed, and where it is therefore in the hands of the authorities to decide whether citizenship is deprived or not. Secondly, discriminatory treatment, as I already showed, a deprivation of citizenship on these grounds, takes in many cases only possible for naturalized citizens, and this can lead particularly to indirect discriminatory treatment, as this makes minorities in general more vulnerable to loss of citizenship. Then lastly, of course, the risk of statelessness. So our data shows that in some of the countries, deprivation on this ground is not possible if that would result in statelessness, but that is certainly not the case in all countries. So there is a clear risk of statelessness in these cases. So to conclude where to go from here, of course, GLOBALCIT will keep updating and extending its data collection in this regard. And in addition to that, we are currently working on a longitudinal data set on security-based deprivation of citizenship that will go back to 1960. And this will help us to see how developments on these provisions have taken place over a longer period of time. And I will leave it there.
Wonderful. Thank you very much, Luke. And thank you again for sticking to time. I haven't even had to give the warning the last two presentations. All right, so just a quick reminder, people are already taking advantage of the Q&A chat function, but just if anybody has questions that come up as the commentators provide their presentations, feel free to put those into the chat. And if your question is for someone in particular, feel free to signal that in the question. All right, so our commentators today, we have three highly distinguished commentators. First, Imke Harbers, who is Associate Professor of Political Science at the University of Amsterdam. She holds a PhD from Leiden University. Her research focuses on subnational political institutions, state capacity, citizenship, and democracy. And she recently started a new project funded by the European Research Council on legal identity and the politics of civil registration. Next, we have Noura Lori, who is an associate professor of international relations at the Pardee School of Global Studies at Boston University. Her research focuses on citizenship, statelessness, temporary migration schemes, and racial hierarchies in comparative perspective with a focus on the Middle East. Lastly, we have Vasily Yuzanin, who is the head of the International Migration Law Unit. He has over 22 years of experience in migration, specializing on the international migration law with a particular focus on human rights law, international labor law and migrants' rights, transnational criminal law, business and migrants' rights, immigration law, borders, and other areas. So each commentator will have 6 minutes. Again, I will hold up a finger when you have 1 minute left, and I will interject if it goes too far beyond that. So without further ado, you have the floor, Imke.
All right, thanks so much for having me, for inviting me to be part of this exciting webinar. And I would also just like to start by thanking the GLOBALCIT team for providing us with this tremendous resource that I can't wait to dig into. And also to congratulate them on completing what I'm sure was a very challenging project. So thanks a lot, and I'm really excited to be part of this conversation. So there are many things I could say about the data set and why it's valuable, and I'll try to restrict myself to just highlighting one thing. So one thing that I think makes this data so valuable and useful is that it provides us with a baseline to the standards to which different countries agree to be held. So they're kind of saying, by putting this in writing, these are the rules by which you can become a member of our political community. These are the rules by which you either exit the community, or you can give up your citizenship, or you lose it involuntarily. And we can use that as researchers to examine the gap between what states formally agree to do and then what they actually do in practice. And this gap can be quite large. And I think this gap between what's on paper, as Bronwyn said, sort of, outright discrimination on paper is becoming increasingly rare. That doesn't mean it has disappeared. And I think this gap between what's on paper and what's in practice is what's something that can tell us a lot about the global state of citizenship, which is something that I've been asked to speak on today. So I'd just like to give you 2 quick examples from my own research, how this might play out. So one relates to citizenship acquisition. where we see in the data and also in the figure that Martin presented that countries generally allow for multiple modes of citizenship acquisition. So the median is 11, and if we look at that, we could think, no, citizenship is available to many categories of people, so it's actually quite easy to become a citizen of different countries. But because these legal provisions exist, citizenship may or may not be accessible to many different categories of people. So, and one of the reasons why this is the case, because any type of mode of acquisition always requires a bureaucratic procedure wherein the state acknowledges the person, as an individual, and also as an individual entitled to citizenship. And let me just give you an example of why this is often challenging in practice, starting with maybe the simplest mode of acquisition, which is by birth in a territory. Even this requires a bureaucratic act, which is the registration of a birth by civil authorities saying this child was born, in this territory, and therefore this child is entitled to citizenship. But as we know from comparative data, around 850 million people in the world lack official documents that allow them to prove who they are and to show their legal identity. And for these people, even birthright citizenship might often not be available in practice. And this lack of identity documents follows them around, even if they move to other countries. So even in the simplest cases, acquisition can be quite challenging. And then I'd like to give a second example with regard to loss provisions, which is also what Luc spoke about. Here we see the same gap. So we might ask which countries allow citizens to voluntarily renounce their citizenship. So to say, I no longer wish to be a member of this political community. And as Bronwyn indicated, we might think about this as quite a simple binary. So either they allow for this or they don't. But in practice, so either there are legal provisions for renunciation or they're not. But in practice, this is often a lot more challenging. So countries might have a provision for renunciation, but they might not have set up a process by which citizens can actually do this. So it's unclear which bureaucratic agency would receive such requests or process such requests. Alternatively, it's possible that there are provisions for renunciation, but they're so onerous that in practice, they're out of reach for many citizens. So even though in theory they can do it, in practice, it's not something that citizens could reasonably go through. And in a recent paper with Abby Steele, we looked at these provisions and we find that 1 in 5 countries globally prohibit voluntary renunciation. Among these countries, democracies and authoritarian regimes are fairly evenly balanced. But if we look more closely, we find that democracies are more likely to follow their own laws. So if they prohibit renunciation in theory, they also do this in practice, whereas authoritarian regimes are more likely to prohibit renunciation in de facto terms. So even though in theory it's possible, in practice we find that it's not. So where does this gap between de jure and de facto provisions leave us as citizenship scholars? I think we need the GLOBALCIT data desperately to provide us with a baseline to know, what the sort of the best case scenario in many instances is. Yeah, I'm wrapping up. But then we need to complement this data with more empirical research looking into what the practice is actually like. This is often difficult because discrimination tends to be hidden from view, and it's difficult to disentangle the lack of capacity from unwillingness. But if we engage in this work and try to uncover the extent to which state actually follows their own rule, we can learn a lot about the state of citizenship. All right, I'm going to leave it there. Thank you.
Perfect. Excellent. Staying within time, MK. Thank you. Okay, let's turn to Noura.
Good morning. Thank you, first of all, for including me. I'm really honored to be able to get access to this data set and also discuss why I think it's so exciting. And so, in 6 minutes, we were asked to address 2 kinds of larger questions. One is, what are the salient issues in citizenship research? And the other is, what are some of the limitations of current tools and the opportunities presented by these new data sets? And so I'll start with the first on questions of, what are salient issues, and just say, at least for me, one of the exciting trends in citizenship and migration research has been to focus on, for lack of a better way of framing it, understanding the nation state system through its margins, through all the people who do not fit, who are not fully included in different nation states. And that requires thinking about, it requires thinking about not just citizenship acquisition or loss of citizenship, but people who spend long periods of times in places where they're not getting access to citizenship rights. And so this might be stateless populations, this might be people who are on temporary labor visas or temporary humanitarian protection that doesn't translate into full inclusion or exclusion, but are partially and conditionally included in different states for protracted periods of time. So this is something I think of as kind of precarious citizenship or legal liminality. And paying attention to this question requires necessarily both understanding acquisition of citizenship and the loss of citizenship. So I understand that these two data sets as being really important to think about in conjunction. I also think of, when we're looking at membership rights and access or loss of access to membership rights, how that impacts mobility rights. And so, not just what being a member of a political entity gives you in terms of benefits, but also how national IDs then translate into things like passports, and whether or not you have access to visa waivers and then can travel across borders. And so these are the salient issues for me, is thinking about how people are really excluded from both membership rights and how that impacts also their mobility rights. And what's I think, as Bronwyn mentioned, it's not enough to just think about the law. A lot of this happens precisely in those gaps between laws and practices and informal practices, but we can't, even getting the laws straight is actually really difficult to do within one case, let alone comparatively. So that's what's immediately very galvanizing and exciting about a project like this one, is that for me, even looking at cases that I thought I knew, suddenly I'm able to see how they compare to other cases that I thought I knew and learned new things. Because when you're manually going through these laws and trying to keep track of trends, it's very different than when you actually are able to plug something in and understand a typology. And so this is, for me, what is most powerful about this tool for both early career researchers and those who are, further along, is being able to, when we're looking in one case and doing this really in-depth qualitative work, to step back and say, what is this a case of? How does this case compare to other cases, whether across nationally, within a region, across regime types? And you've already seen some evidence of that, and Martin's comment about European states are more likely to be in this direction, or autocratic versus democratic states. And so for me, because I look at the Middle East, I think there is and specifically on the Gulf cases, where you just have extreme levels of exclusionary citizenship in many ways. And we're talking about a context in which 60% of the aggregate population of the Gulf is made up of non-citizens. In places like the United Arab Emirates and Qatar, 90% of the population is made up of non-citizens. And so understanding these cases, for me, one of the hardest challenges was understanding, are these deviant cases from global trends? Are they exceptions to global trends, or are they actually where we're seeing global trends in their most extreme form when it comes to exclusionary citizenship? And so that's one of the immediate tasks that at hand, or one of the immediate tools that I think that these data sets provide, is the ability to understand variation, both within a particular region and then across regions. And one thing, when we're talking about the Middle East, is not just this exceptionalism that comes from scholars who are not from the region, but even internally, like coming from the region, I realize that I've internalized a lot of notions of exceptionalism, particularly when it comes to gender-based discrimination. So one of the things that, you see in the literature is this idea of, like, Muslim majority states, women cannot provide citizenship to their children. And so in one of the pieces I was working working on, I really made it about, well, in the Middle East or in Muslim majority states, the relationship is between citizens and families as opposed to Western states. And I got, I think once you look at a data set like that, that's not really a clear bifurcation of the globe. And so thinking a bit more about these kinds of trends when it comes to gender-based discrimination is really important. All right, well, I'll stop there because I know I'm out of time.
Perfect. Right. You're right within time. All right, let's turn to our last commentator. Vasily, go ahead. You have the floor.
Yes, thank you very much. And thank you for having me at this very important discussion, and congratulations on this database. Let me perhaps start with an important statement from legal perspective. Well, as a lawyer, I have to do that, and perhaps I will move more to the issues of practicalities and migration policies and how the database may support the policy development in migration and in the issue of in the area of state citizenship. Well, of course, the general premise of the international law recognizes that states have sovereign right to define who are their citizens. That does not mean that there are no regulatory frameworks, and they are coming from various branches of international law, international human rights law, starting with UDHR, as well as other instruments, ICCPR, ICRC, and Migrant Workers Convention. Of course, there are important instruments that are put there from this area of law related to nationality, citizenship. We know the key instruments there: 1930 Convention on the Reduction of Statelessness, on the status of stateless people. There is jurisprudence around this matter. Just wanted to say that there are, despite of the sovereign right of states to decide on the issues of nationality, there are the frameworks, the principles that are there that put the shape for the national laws. And of course, few principles were mentioned here. The principle of non-discrimination is a key one, as well as the principle for states to avoid, not allow the status of statelessness for people. But let me come to this question from the policy perspective. There is a clear and very obvious link, a nexus between citizenship and migration. And I would like to define 5 issues here. First of all, citizenship gives all access to all possible rights in the area of migration. Not only the right to live, which is available for all selected of place of residence, but the right to enter one's own country, which is reserved for citizens and residents. But also an important thing is that citizens may not be expelled from the country, so from their own country. So this is a point where, for instance, migrants having their immigration status may find themselves in the situation of vulnerability. Second issue is linked to the call to the so-called issue of strong passports, which usually refer to a number of states, one passport allowed to visit without visa. And this visa-free access to certain countries certainly facilitates the mobility, sometimes even create or put the shapes for mobility corridors. It creates also opportunities for investment, climate, economic cooperation, business development, skills transfer, all those nice things that we want to take from migration, from mobility. Point 3 is closely related to the above, is access to labor market. So that may mean to not only to occupy certain professions, but also to have privileged access to the labor market in general, being a national of a country, for instance, coming from regional integration process. Fourth is access to rights and rights protection mechanisms, various administrative commissions, courts, and tribunals which are available for citizens of particular states. And finally, the fifth one is political rights, possibility to have a say inter alia on migration policy and rights. So that may be done by virtue of the fact that a person has second citizenship, allowing it or having access to rights which are normally reserved for nationals, which is voting. And nowadays there are a lot of situations when migrants, foreigners, may be admitted to the local elections, or in certain cases even to the national elections. Now, coming quickly to the issue of how the database may be useful for policy development. It's an excellent instrument for the UN agencies and international organizations in the area of capacity development, giving access to all this knowledge and laws. Excellent instruments for states for migration policy formulation in the area of migration, but also in the area of citizenship. For instance, which countries we may look at to sign the bilateral labor migration agreements or mobility agreements or skills partnerships, how to shape integration policies, visa policies, entry, exit policies. Mobility and economic development are very close, so facilitated access to economic rights, social protection, for instance. This is also an important instrument for shaping the policies in the area of citizenship. Many states are looking for better opportunities for their nationals and for migrants on their pathways to nationality, on how to create the pathways to naturalization, how to handle the issue of denunciation of nationality for certain jurisdiction, how to avoid certain pitfalls, and how to ensure that, for instance, despite of the fact that the laws do not foresee any discrimination, how, for instance, through the implementation, the discrimination may become an issue. So congratulations on this to the GLOBALCIT for the development and the update of this amazing database. And I think it will become an important source of information for policy and legislation development in this area. Thank you very much.
Wonderful. Thank you very much, Vasily. So we'll turn now to the Q&A portion. And I think I'll take the chair's prerogative and ask one of my own questions. And then I'll turn to reading those that we have in the Q&A. So first, my question is, especially based on the commentators' remarks, right? We're seeing this trend in terms of gaps between law and practices. And as someone who studies differences between what the text of laws say and what the text of the regulations that are provided for the implementation of those laws say, are there any plans for ways to try to capture some aspect of these divergences, maybe a history of it, or some other way of finding an opportunity to sort of operationalize this really critical aspect? And I think Martin and Bronwyn might be well suited to answer this, particularly since Luke has many of his own questions in the Q&A, though Luke, of course, feel free to respond to mine as well. So let me turn to reading some of these questions in the Q&A, and then we'll go to our speakers to respond. So first, Sarah Poley asks, if you know of any cases in which a certain EU citizen was deprived of its citizenship because he was also a Russian citizen under the Golden Passport scheme, but was hit by sanctions. Therefore, the member state that had granted citizenship withdrew it as a result of the imposition of the sanction. And so this is particularly for Luke, but again, if anyone wants to chime in. Sarah also asks a perhaps more technical question, wondering whether service in a foreign army covers the case of foreign fighters. So I'm thinking the distinction Sarah's drawing here is between, whether it's the army of a sovereign state versus something that might be more diffuse or informal. All right, and then Mahesh Kumar Kushwaha asks, it says, thanks for this wonderful resource, and asks Luke again on the securitization of citizenship. Luke, if you could share a bit more on what factors or indicators the dataset uses to determine securitization, and are they standard across the globe? And it looks like Fabian Guzau's question was already answered regarding this issue of dormant citizenship in the case of dual citizenship. But if anyone wants to provide any additional comments beyond the answer that Bronwyn provided, I'll go ahead and read out this question. So does GLOBALCIT include information on the concept of dormant citizenship in the case of dual citizenship? For instance, persons with a Spanish citizenship acquiring a citizenship in certain countries and not residing in Spain. And as such, they can't vote in Spanish elections until moving back. And so Fabian notes this is something that's being discussed in Germany. And Bronwyn did already answer, so I'm reading this all out loud for the recording purposes. Bronwyn does answer that the GLOBALCIT does not consider voting rights, but legal status as a citizen. For external voting rights, see, for example, the international IDEA project, and Bronwyn provides a link to that website. So why don't we go ahead and start taking the responses from our speakers in the remaining 8 minutes we have, and if there's still some time, we can entertain some more questions if they pop up. All right, so Martin, do you want to start?
Yes, why don't we give Luke the chance first to respond?
Okay, Luke, why don't you start?
Thank you. I guess we'll start with the questions that were directed to me in the Q&A, and then I'll leave some space for Bronwyn and Martin to also address your very topical question. So first of all, does service in a foreign army cover also the cases of foreign fighters? Yes, it's a great question. Well, in general, these particular provisions are limited to service in a foreign army of another state. Then there is in certain countries some debate whether that is restricted to recognized states or whether that could also include unrecognized states, but as such, it is limited to states. So services to for example, a terrorist organization or participation in a terrorist organization, this would be covered by provisions that we consider as disloyalty provisions or national security provisions. So regarding the question whether Russian citizens hit by sanctions were deprived of their Cyprus citizenship, I do know that in the nationality law of Cyprus, there are very broad deprivation provisions, particularly for persons who acquired their citizenship through investment. And indeed, one of the grounds on which they can be deprived of their citizenship is if they are on the EU sanctions list. Including to many other grounds. For example, if an Interpol notice has been issued against that person, that can also be a grounds for deprivation of citizenship. I know that quite a few Russian citizens have been deprived of their Cyprus citizenship. Whether this was because they were on the sanctions list, I don't know. All right, then regarding the question on the factors and indicators that the dataset uses to determine securitization. Well, first of all, the goal of the dataset is to capture and describe legal provisions, and therefore our categorizations are rather broad. So, for example, a very common international law standard regarding deprivation of citizenship on the basis of disloyalty is whether that person has shown any behavior that is considered seriously prejudicial to the vital interest of the state. In earlier iterations of the dataset, we actually included that in the definition for disloyalty provisions, but we decided to actually broaden this category because we didn't want to restrict it particularly to provisions that fall within the scope of this particular international law standard. So as such, I can just say that we use very broad categories that enable us to capture as many provisions as possible. Yes, rather than really using a set of indicators that capture securitization. Okay.
All right, shall we turn to you, Martin?
Yes, sure. So thanks a lot, everyone, for your great questions. Too much to say in a few minutes, right? But I wanted to address two big topics. So law and practice, and secondly, combining acquisition and loss, right? And so let's say talk first about law and practice. So of course, as Bronwyn mentioned this already, we are very aware that coding is difficult, right? We are very happy that we have now coded the citizenship law for 191 countries, all the different ways in which you can acquire it according to the formal law, right? But then, of course, the next question is, okay, what goes beyond this? So I think it's a fair question. It's not easy to do. First of all, it's certainly an ambition. We've done some previous projects in Europe on implementing nationality law. So we are interested and have the ambition in time perhaps to go beyond the formal nationality code. But we try to incorporate this already a bit more to some extent. And so let me give two examples. So the first thing is that our data allows to combine various elements of citizenship law. And so when you think of a renunciation requirement, for example, when we talk about coding dual citizenship, Spain has a renunciation requirement. When you want to become Spanish, you have to renounce your citizenship. But then you can ask, how effective is this renunciation requirement, right? Because in the Netherlands, if you want to become Dutch, you have to renounce your citizenship. Once you become Dutch, you have to demonstrate that you have renounced your previous citizenship, right? And if you don't do this, there's a corresponding provision of loss of citizenship, which we code. That means that if you have not renounced the citizenship, even though you promised to do so, then you will lose your Dutch citizenship. Actually, you will have never acquired it. Whereas in Spain, such a provision does not exist, right? So combining the different elements of the citizenship law already helps us to come a bit closer to what you might say is the practice, right? Or at least the effectivity of it. And that's what we already code now in the version 2 of the data set. So secondly, and this is closely to what Imke's paper in the International Migration Review recently on renunciation. So you use the data from a predecessor, the Maximite data set, where we had included in the code book some notes on whether in practice, whether there's evidence that in practice renouncing citizenship is difficult, even though the law formally says that it should be possible, right? And that information we have now also coded. So then it's up to you, of course, on how to use this, right? So you can say, well, the nationality law of Morocco says that you can renounce Moroccan nationality. So we think that formally it's possible, but there's all kinds of evidence that says that in practice it's not, right? And so we code also this additional evidence with resources. I think that's important. It will allow users to have a more fine-grained approach. So finally, on maybe combining, so first of all, on Vasily, I think you're very right to point out the links between citizenship and migration, right? And we have also structured the data set in such a way that it allows us to combine the information, for example, with data on what you refer to as the value of citizenship, right? Is it the case that this allows for, is both relevant for policy makers, but also for researchers? Are those more valuable citizenship more difficult to get, or are there differences? Right, so you could imagine that there's some kind of trade-off, although I don't think it's necessarily like this, right? When we look at acquiring citizenship of autocratic regimes, this is not typically the most valuable citizenship in terms of visa-free traveling, but it's often very difficult to get, right? But I think this opens up an interesting research agenda. You mentioned political rights, so here to make one clarification on the question on the dormant citizenship. But actually, apart from citizenship law, we also look within GLOBALCIT at what citizenship means in terms of electoral rights for mobile people. If you move abroad to another country, do you maintain voting rights, for example, or are voting rights restricted to citizens resident in the country, or may non-citizens who are resident in the country also have voting rights? Right? We see that there are various trends And we're currently working on another part of the GLOBALCIT team is working on coding all these electoral rights, and we hope to publish these later in the year. And this would, of course, exactly allow us to approach those kind of questions, Vasily. Well, there's more to say, but I keep an eye on the time, so maybe I give the floor to Bronwyn to give a few more comments.
Just a word on the gap between law and practice. And the data set does include quite, there are comment boxes where, for example, the case of Tanzania, the law says that there is jus soli citizenship in Tanzania, but it is absolutely clear, including an opinion from the Attorney General, that jus soli law is not applied. What do? The law says one thing, the top legal officer in the country says it means something else. All we can do is put, as it were, an asterisk. As Martin says, thinking about, well, how can one code the asterisks, as it were, in a more systematic way? But it's very difficult because we only know that for some countries and not for all countries. So it's, you can put in the asterisk, but it's hard to code it because you can also then create a false sense of security. And I think, the data set is an amazing resource, but it can also create a false sense of security that this is what the law is, because it's so systematic. It creates the idea that this amazing amount of work has been done, therefore this is the truth. But it's always more complicated than that. And I think that, using the data set should always be with, this is a starting point to enable me to ask questions, rather than these are the answers to the questions that I want to ask. Because with, no data set of this type can be absolutely conclusive, because there are always questions of interpretation. And the interaction of the different provisions with each other and how they cross-refer has always to be brought in mind as well.
Thank you very much, Bronwyn, for the concise response. I think we've run up on time here, but I would just add the country reports too are such an excellent resource on digging into those details. And this data set is obviously an extremely impressive amount of work and will be very useful, as Nura pointed out to me in the chat, in terms of the variation we see over time and over space is really something to be celebrated. So thank you all very much for attending today. Thank you to our speakers, to our commentators, to the audience. And as a reminder, you can find this recording on globalcit.eu at some point later this week. So thank you very much again for attending, and be sure to check out the new data set.